responsible for supervising 10 of those 16 kids in her care were out of sight of that teacher. She was talking to another teacher, and 10 of those 16 kids were out of sight of that teacher for what the court said was a significant period of time. Now, there was some dispute about how long actually 10 of those 16 kids were away from the teacher, to where that teacher didn't have, that observation of them. There was some dispute about that, but the court did say that it was, there's no question, it was for an unreasonable, lengthy, significant period of time. So, and again, a lot of these things that I'm telling you, a lot of this is just good common sense, and y'all know that. You've already got good judgment. You've been doing this job for years, and I'm not telling you anything that you don't necessarily know. But what I'm saying is that common sense that you use every day, the courts require it. The courts require it, and when lawsuits are filed, they're going to want to see, did you use good common sense in the supervision that you provided? Was the ratio proper as far as the supervision numbers of you and the children? And I know that that can be a decision by the administration. You may not have some involvement in that, and that's where the administration can get pulled into litigation also. We'll talk about that more. But in that common sense, did you provide proper supervision? And was it actually, were you actually supervising adequately? Okay. I did, in doing research, I found a number of other cases. I want to read some of these to you. Some of these facts and situations might sound familiar to you. And it might concern you a little bit because some of you are thinking right now about incidents that have occurred in the past. And you might be thinking, okay, how did I respond to that situation? Was that a foreseeable risk? Is that something that I properly did to minimize? There's a lawsuit that was filed in Mississippi that went to the Mississippi Supreme Court in 2008. Todd versus First Baptist Church. The mother of a 2-year-old girl or a 3-year-old girl saw damages for injuries that her child suffered while at a church's preschool. The church had moved for summary judgment, and the circuit judge had thrown the case out. Summary judgment means that lawsuit's been filed, the defense has presented their position, and a judge says, you know what, I'm going to throw this case out. I'm not even going to let it go to a jury. And in this situation, the judge had done that, had thrown the case out, and it went to the Supreme Court on whether or not the judge's decision was correct to throw the case out. The facts in this case is that while talking to a parent, okay, the teacher responsible for the child, again, they were going, the mother of the girl, the child was about to board a bus. But while talking to a parent, the daycare worker turned her back to the children, talking to another parent. The girl was then assaulted by a classmate and received a significant cut across her face from her cheek to her jaw, significant injury. The injury led to several reconstructive surgeries and unfortunately a permanent scar. It was alleged that the boy that assaulted the girl actually kicked her in the face. The teacher claimed that she didn't see exactly what happened. She had been distracted and was talking to another parent. And the court looked at it and said, you know what? We find that this was not unreasonable for this teacher to have been distracted for a moment, turned around, talking to another parent. As picture every day, I remember my wife and my kids were 3 and 4. Every day she wanted to go talk to the teacher. Well, what happened today? How'd they do today? What's going on today? That type thing. And I know that you get, probably nibbled at the end of the day by parents. And like ducks nibbling on you or something, And I understand that it's going to be very easy in that circumstance that you would be distracted. Now, in this case, the court said, yeah, this teacher got distracted, but you know what? It happened for just a moment. And it's not like she was distracted, reading a book. She was distracted by talking to a parent who would come up and began asking questions. In that circumstance, the court noted, and they ruled for the defendant, the court noted that this particular teacher, the time frame was very short. And also, the distraction that occurred, she was talking to a parent. And they said, based on these circumstances, we cannot find that teacher was unreasonable in the supervision that she provided. And we can't say also that this was a foreseeable risk. There had been no notice. There had been nothing that had happened prior to this situation where this little girl was being targeted by this particular boy, where this little girl had been threatened by this little boy, where this little boy had exhibited violent behavior to other people necessarily. It just happened completely out of the blue, just like that. And the court said we don't have foreseeable risk here, and the teacher acted in a reasonable way. But that was a lawsuit that was filed, folks, you know, and it went all the way to the Supreme Court. It's a difficult situation, and I dare say that if you do your job long enough, we're unfortunately in a very litigious society. You know, folks file a lot of lawsuits now. Okay, if you do your job long enough, there's potentially a situation that you might get pulled into. I hope it never happens to you, but it could potentially happen. And that can be a long, arduous process. But remember, if you follow the rules that the courts say, what foreseeable risks are you seeing? Are you adequately then responding reasonably to those risks and minimizing the dangers? You can't eliminate all of them, but minimizing the risk. Then, like this situation, the case will be thrown out. Had another case. This would involve Simpson County School District. While waiting for a school bus to arrive, an 11-year-old female student, she walked back into the school to use the bathroom, waiting for the school bus to arrive. And during this time, she was waiting for the bus to pull up to take her home. During this time, she alleged that 2 male students forced her into the boys' bathroom and actually assaulted her sexually. In her suit, the student claimed that the school district failed to adequately supervise these students. And you might be thinking, well, this is a public school, we're in the MPSA, but the Supreme Court was very quick to say, in the St. Andrews case, that the law is the same. Whether it's public school or whether it's private school, it's the same standard of care. Now, in this situation, the court had to determine whether or not the school, the teachers that were responsible for monitoring the security of these, and we're not talking about 3 and 4-year-olds here, we're talking about 11-year-olds, whether or not there had been adequate supervision that was provided. And in this case, the court found that the principal had assigned 3 different teachers and adults to supervise the loading of the buses. And that's, given the number of children that were out there, that was a significant number as far as the teachers being there. It minimized the ratio quite well, and that this was a very quick incident. She stepped back in to use the restroom, and it happened just like that. And again, what did the court want to look at? Was there any foreseeable notice? Was this a foreseeable risk? Had the school been given any notice by complaints of this child or by aggressive behavior by these boys that they were aware of that required them to pay particular attention to these children, to these boys, and also monitoring the security of this particular girl? And the court said, you know what, we can't say that that was the case here. And so they found, in fact, for the school district, okay, applying all those same standards of care, foreseeable risk, minimizing any kind of danger. Here's another one. A summer youth program director supervising children. This was Slade versus New Horizon Ministries, went to the Mississippi Supreme Court in 2001. The summer youth program director supervised children to a designated area to load onto a van. One of the participants bumped into the plaintiff, this child, knocking her down, and it actually broke her hip. The plaintiff claimed her parents sued on her behalf. The plaintiff claimed inadequate supervision due to the person's absence from the immediate area. The person that was responsible for supervising this activity, them getting on the bus, that director of that daycare of the youth program, had stepped away for a moment as they were boarding the bus. Okay? He was not within reasonable proximity when the incident occurred. What happened? The court said that there had been no notice that of any foreseeable risk of any other student assaulting this child. Then no notice of that. And guys, you know how you can get notice of that circumstance. Y'all know, you're there every day. You're going to hear things from other kids. You're going to hear potential bullying or something like that. And in this circumstance, the court said there was no foreseeable risk. Again, there was nothing to put the program staff on notice that there was a potential danger or risk here. So what did they do? They threw the case out also and ruled for the defendants in that case. And they said this, and I think this was interesting. They said that this could have happened even if the director had been standing there, because it was so quick. And the fact that the director was not in the reasonable proximity of that location when it occurred, they said that alone is not enough to establish liability for the daycare of the school. Okay? Any questions? Okay, got one more case here. And this was a case in federal court involved a 5-year-old girl. Miller was the plaintiff's name. A 5-year-old girl claimed that during nap time, this horrible stuff, a 4-year-old boy removed some of her clothing and lay on top of her.